A very good evening, honorable judges. We're just taking 2 more minutes and let's start the session. Apologies for the delay.
Good evening to all, esteemed participants and distinguished guests. I'm Shomili Kundu and it is my privilege to be your host for today's momentous occasion. On behalf of the entire team at the Amikus Qriae, I extend a warm welcome to each of you to the valedictory ceremony of the third edition of the Sankhla and Associates National Virtual Moot Court Competition 2024. We have been delighted to collaborate with our esteemed joint organizer, Sankhla and Associates, to bring this prestigious event to life. Allow me to briefly introduce the Amicus Curiae. Conceived by a consortium of leading legal scholars and renowned professionals from both India and abroad, the Amicus Curiae represents a visionary online platform dedicated to advancing legal knowledge. Our mission is to disseminate comprehensive legal insights and foster a deeper understanding across various legal domains, ensuring that our resources reach every corner of the ever expanding legal community. With a focus on contemporary legal challenges and ongoing developments, TAQ contributes significantly to the discourse in the legal field. We are registered under the Indian Partnership Act of 1932 and the Ministry of MSME, Government of India, and proudly stand as the 8th largest legal website in India, connecting over 20,000 law students from more than 80 law schools across the country. It is my distinct honor now to introduce our joint organizer for this competition, Sankhla and Associates. This distinguished law firm offers a comprehensive range of legal services with both national and international reach. Sankhla and Associates collaborates with top solicitors from Singapore, the United Kingdom, and India, providing tailored legal solutions to individuals, firms, and organizations. The expertise spans insurance law, bankruptcy law, debt management, corporate law, advisory, and insolvency laws, among others. With a reputation for excellence and commitment to the highest standards of legal practice, Sankhla and Associates shares our vision of promoting legal expertise and professional development through this competition. Now, I'd like to introduce Mr. Kapil Sankhla, our distinguished Patron-in-Chief. Mr. Kapil Sankhla, who established Sankhla and Associates approximately 20 years ago, is the company's managing partner at the moment. He has been practicing ever since 1999 and received the coveted 2016 Super Lawyer of the Year. His background includes a wide range of topics related to disputes, corporate and legal advice, litigation and arbitration business related issues, white collar offences, employment, infrastructure and public policy issues, governance, ethics and policy are all related. He has been recognized as one of the top attorneys in India, occasionally appearing in several media. Now, I'm delighted to invite Kapil sir to share a few words with us. Let's give him a virtual round of applause and welcome him to the screen. Over to you, sir.
Thank you, Somri. You've been very generous with your compliments as always. There is only one error which I have to quickly rectify, otherwise I will be in deep trouble. You see, I've been a lawyer for now more than 25 years. And why this is important is because I'm contesting in the Delhi High Court Bar Associations as member executive 25 years standing. Now, I have to clarify this because if I was 20 years, there would be a lot of people wondering how the hell can I actually contest at a 25 years post. Having said that, it is an absolute pleasure being here. To all the honorable judges, to the distinguished guests, aspiring advocates, I take this opportunity to welcome, first of all, our Chief Guest, Honorable Justice Ravi Shah, former Chief Justice, High Court of Punjab and Haryana. I've had the privilege of appearing before you, sir. His Lordship was an active and in continuous practice in the High Court of Madhya Pradesh since the day of enrollment, and the CAT and SAT since their establishment, and continuously and extensively dealt with constitutional wise matter, tax, NSA elections, other constitutional matters for the states of Madhya Pradesh, apart from civil services, constitutional, criminal matters. And he's had a wonderful, he's been very, very generous and kind on the bench to young lawyers, and it was an absolute pleasure, sir. To our Chief Guest, Justice S.G. Shah, retired Judge, Gujarat High Court. Justice Shah had an extensive legal practice even before, spanning various fields, including civil, constitutional, revenue, and criminal law. As a distinguished judge, he has adjudicated over 1,300 cases in several courts, resolving 19,000 cases in the High Court, delivered verdict in more than 88 cases as a CBI judge. To our guest of honor, Professor Dr. Manoj Kumar Sinha, Vice Chancellor, Dharmashastra, National Law University, Jabalpur. Of all the NLUs I've taught, I don't think I've taught in Jabalpur yet, but looking forward. Mr. Sinha, prior to joining DNLU, has served the National Law Institute as its director. His areas of specialization are human rights, constitutional law, international humanitarian and refugee law, international criminal law, and international institutions. I also welcome our guest of honor, my colleague Nivedita Chauhan, co-founder, Chambers of Abhinav Mishra, advocate, practicing in the Honorable Supreme Court of India, inter alia, who was in fact kind enough to grace us on the opening ceremony and gave an inspiring talk to all youngsters. Ms. Nivedita holds expertise in streams of real estate, corporate, commercial, intellectual property laws. A dedicated and meticulous approach has contributed to several notable judgments. But beyond the participants who have been the blood and soul of this moot court, I would genuinely like to thank the Amikus team, all of you, who have been the body and have manifested this dream into reality. It was during lockdown that Rupam had contacted me with an idea to have a national level moot court, and has perhaps single-handedly managed to make it happen, of course, with a wonderful team with him. It is indeed heartening to see young legal minds delve into one of the most cherished pillars of our democracy, Article 19 of the Constitution of India. The right to freedom as guaranteed under Article 19 is not just a set of legal provisions, but the very soul of our democratic existence. Freedom of speech, assembly, association, movement, and as I discussed, all of the other things about the RTI, etc. These are not just mere words, but the lifeblood of a free society. I remember the words of Justice Brandeis of the US Supreme Court, who said that the greatest threat to freedom is the inert people. And I believe, as he did, that the responsibility of safeguarding freedom does not rest only with the government or courts, but also with the vigilant citizens. As the custodians of law, we must ensure that these rights are not eroded by the whims of transient political powers or the pressures of expediency. And moot courts such as the one that you have participated in are not just about arguments or about judgments. They are an exercise in understanding the deeper meaning, and in this case, the deeper meaning of freedom. They ask you to consider, to debate, and to defend the very principles on which this nation was built. Through this process, you have engaged not just with the text of law, but its very spirit, its very essence, its very conscience. The moot proposition that you encountered in this competition has offered valuable lessons, I am sure of that. It required you to engage with the complex relationship between morality and legality, the question of whether morality should prevail over legality, particularly in the context of obscenity, and to debate evolving interpretations of obscenity, vulgarity, morality. These concepts have always been shifting like the sands of time. And this moot must have provided all the participants with a very nuanced understanding on how law grapples with the changing societal norms. You see, our constitution is not static. It is a living document that must adapt to the changing times while preserving its core values. Article 19, more than any other provision, embodies this balance. It is a reminder that while our freedom are fundamental, they are not absolute. They are subject to reasonable restrictions aimed at maintaining public order, decency, and, of course, morality. But these restrictions should never be used as a tool of suppression. I've always maintained that the strength of our legal system lies in the continuous striving for justice, fairness, protection of rights. Your role as future lawyers will be to ensure that the freedoms enshrined under our constitution, particularly under 19, continue to be the beacon of liberty, even in the most challenging of times. Your participation today is a testament to your commitment to this cause, and for that, I applaud each one of you. To the winners that we will disclose in some moment, my heartfelt congratulations. But remember, true victory lies not in the winning, but in the understanding of the values that you are defending. You are the torch bearers of our Constitution's legacy, and I'm confident that you will carry it forward with integrity and with passion. So, in conclusion, I leave you with a thought from Dr. B.R. Ambedkar, who said that constitutional morality is not a natural sentiment, it has to be cultivated. As you progress in your legal careers, my friends, may you cultivate this sense of morality and safeguard the rights and freedoms of all citizens with the same zeal and dedication that you have shown in this moot court. I thank you all.
Thank you, Kapil sir. We are truly grateful for the opportunity to host this event in association with your eminent law firm. Your insights today have been incredibly enlightening, and we appreciate your valuable contribution to this competition. Now, I'd like to introduce Ms. Nivedita Chauhan, co-founder at Chambers of Abhinav Mishra, a practicing advocate at Supreme Court of India, who is our today's guest of honor. Being the co-founder of the Chambers, Ms. Nivedita holds expertise and has worked rigorously on real estate, corporate, commercial, and intellectual property laws over the years. She has been an asset to the Chambers and has managed both legal and administrative aspects of the Chambers with great efficiency. She has worked extensively with a number of startups and advised such companies on various legal and regulatory compliances, and has also assisted in execution of various agreements. Her dedicated and meticulous approach has allowed her to provide able assistance in procurement of several notable judgments. She has organized various legal awareness camps and is an active participant in the promotion of human rights. Now, I'm elated to invite Nivedita ma'am to share a few words with us. Let's give a virtual round of applause and welcome her to the screen. Over to you, ma'am.
Thank you so much, Sonal, for the kind words and for the nice introduction. I'm still very young in the profession, and I'm very lucky and privileged and grateful to share the dais with this platform with such great luminaries. Thank you to Kapil sir and Amikus Qriae for having me here for the third Sankhla and Associates National Virtual Moot Court Competition 2024, which, like always, have been a tremendously successful event. I extend my heartfelt congratulations to all the participants who have showcased their dedication, intellect, and I have witnessed one of the rounds, that is semi-finals, where I witnessed the genuine efforts being made by the law students merely second or third year law students, and the arguments they showcase, it was commendable. And I'm thankful to the organizer for giving them such a platform that they can argue from the comfort of their home by organizing this virtual national level moot court competition. At this juncture, I would also take a moment to recognize our distinguished chief guest, Justice Ravi Shanker, retired Chief Justice of Punjab and Haryana High Court. It may be a coincidence, but today I appeared in the same High Court where Justice has been the 65th Chief Justice of the said High Court, and Justice Subodh Shah, retired Gujarat High Court. Indeed, there are no words, enough words to praise your lordships for making the profound impact in the legal landscape during their tenure. And I believe your lordships are still engaged in doing so by way of arbitrations. If not, I was not lucky enough to appear before your lordship's court, but God has been very kind that I'm sharing this platform. And with God's graces, I'll be doing some arbitrations also with your lordships. And I can also see that recognize Dr. Manoj Kumar Sinha, the Vice Chancellor, DNLU. What do I say about you, sir? I think you have been a guiding light in the legal education, or I would say a margdarshak to many bright young legal minds. You've been training them in various legal institutions. And many more contributions I need not state, which goes without saying. And lastly, or firstly, Mr. Kapil Sankhla has stated and had called me his colleague. But sir, I am way junior to you. You're my senior. You're the person I look up to. You're senior at the bar, and you are my mentor. I may be your colleague. You're very humble. You're very kind, but you are my senior, and will always be the one. Thank you so much.
Will always be my colleague.
That's very kind of you, sir. I have seen your interviews and what you portray yourself as a law student of law, and that is seen from the passion you have in contributing and promoting the clinical legal education by organizing such events. And as sir has mentioned, that sir also teaches in various university, and I think most of us must learn from sir that besides the busy schedule, one must always contribute to the development and promotion of clinical legal education. And I'm glad to be a part of it. And this is the second time I'm a part of it, and I want to be a part of it in all the endeavors sir makes in the future. As I say, all the legal like minds should come together to do something good for the society. Thank you so much, sir, for having me. Now, coming to the Moot proposition, this is not the first time. I think the Moot proposition has always been drafted in a manner by the organizers, which creates a balance between society and other important sectors related to development, progress and growth, law and order. And this is another one example. India has been very diverse in culture and religion and morals. And within this country, it has many diverse community with diverse beliefs. There may be something obscene to some community, which may not be obscene to the other. And this is what the Moot proposition mostly focused upon. That was the selling of the sex toys with emphasis on Section 292 of IPC. As I've mentioned that India has had diverse culture, even Section 292 of IPC provides exceptions to religion and archaeological sites having carvings portraying of that nature. In the Moot court, a very important issue which was raised vis-a-vis the issue of selling sex-related toys in the market, that the students try to connect it with sexual and health well-being. And I'm glad to see that various reports of FDA and other researchers were being relied upon. And this is something which is always encouraged to the law students to not confine their research and arguments just to the moot court proposition, but to go out of the box and do the research and come up with great ideas before the court. Because even the court, I think justices would agree with me, sometimes even the courts are stuck at a point that there has to be a solution. So it is always encouraged from the lawyers to come up with suggestions into a particular matter, to even assist the lordships to reach to a fruitful conclusion, particularly in these matters when two fundamental rights are at stake. One being the right to practice your own profession or form your own association or practice any or open any business, particularly Article 19(1)(g), the Moot Code was based upon. And the concept of morality, obscenity, or based on which the government is entitled to impose reasonable restrictions as per Article 19, Clause 6. So the problem the Moot Court basically focused on that to what extent the reasonable restrictions can be imposed. Can it be in an absolute manner? So I'm grateful to all the participants who had argued. They came up with brilliant arguments, as in that it is not the practice, it is the manner in which something was being sold. And the arguments from the other side was that there cannot be absolute restrictions. That of course can be the amendments can be suggested. There cannot be absolute bar to an activity. There can always be regulations. There can always be controls and regulations which can be set up to mark a balance between, to secure both the interests, that is societal interest and the business interest. So I'm grateful for the entire, for the organizers to create a platform for such holistic and vivid discussion on such an important issue. Given the fact that such activities are also on the rise, both on e-commerce platforms and in other countries, there are stores which are indulged in selling toys and objects related to sexual wellness. And which I believe to a great extent is being ignored or overlooked in our country. There has been this has been a debatable issue over a period of time, that how important it is to impart sex education in the books, in the primary education, primary, secondary, and higher education, to make the children understand from the very threshold about these things. So times, of course, the legal landscape change with the developments and the needs of the society. And that is what I'm glad that the platform was created to discuss on this aspect. Thank you so much. And I'm again grateful to share the platform with such great dignitaries. And I wish all the best to the students who could not win. I appreciate the hard work you've been put in. There are always chances. This is just a trailer. You're being trained. Just take your learnings ahead, whatever you've learned during your rounds, whatever grillings you faced. I will admit here that, while judging the moot court, the object is always been to teach you to be prepared to argue in the real world. I can't deny it gives the judges also. It is quite fun to the grilling, and you will understand. And these all the grillings which are coming from all the practitioners who have practiced in the real court floor, and the grilling they have faced, and which actually has shaped them also as an advocate. Therefore, even if you become an advocate, even if you enter the legal profession, if you hold a bar registration, you're always learning. You always come across judges and in the courtrooms, in the
extensively in the fields of international law, international relations, constitutional law, and international human
Kapil,
rights.
you can leave it there. Oh, thank you very much. Don't go for Honorable Justices are sitting here. So, Honorable Justice Ravi Shankar Jha, sir, retired former Chief Justice High Court of Punjab and Haryana. Honorable Justice Subodh Shah, sir, retired former Judge Gujarat High Court. Our respected Kapil Sankhla ji, the Managing Partner Sankhla and Associates. Nivedita Chauhan, co-founder Chambers of Abhinav, Mishra, Advocate, Honorable Supreme Court of India. I feel it's a privilege and honor for me that I'm sharing dice with the Honorable Justice Ravi Shankar Jha, sir. Though I could not meet, but I know that it's because of you I'm here. So you gave the foundation of the Dharmashastra National Law University and the place and also to the city in new law school. I'm really thankful that virtually I'm meeting, but I'll seek an appointment, Lordship, and I'll come and pay regard to you someday. Everybody speaks about you, your contribution, and we need your more support to take it to the final shape. So we are moving, we are progressing, but still we have to walk a little bit. So I'll come and discuss with you, but it's a great honor, and I thank Sankhla ji and also Rupam. In fact, he asked me to call you. I said, it looks odd. I will seek an appointment. I can't call Lordship like that. So one day I'll call you, seek an appointment and meet you, Lordship, in your place. So I'm very thankful for the law school and I'm here and I'll get your patronage and support for the taking this national law school. Respected Justice Shah said, it's a great honor for me and privilege that I'm sharing dice with you. And Sankhla ji, Kapil Sankhla ji and Nivedita. So when the program began, I think we are not so lucky that because I could not see the problem also. So I was not sure what to speak, how to speak. But our burden has been heavily shared by both previous speakers, particularly Sankhla ji and Nivedita. Nivedita spoke in detail about not about the problem, also the challenges which young law students face when they come to the profession. But most important point, what she emphasized, those points are more ethical and value loaded. That is very important point with what you said. You gave an example how your colleague has advised you. Don't work much. If you pay less, you have to work according to payment. So, but I believe that you believe in work, and that is important. We should give best services, whatever way we can contribute towards our client, students, profession. The moot court, I'll just take few minutes because two honorable judges are sitting, so I'll not speak much. But I think this initiative, which began in 2000 during 2020, when entire world was unsure how to go about, how we'll tackle the education in the university, how to conduct the examination, how to conduct the practicals, moot court, and all these. In one moment, everything changed. 22nd of March, I remember the day 21st or 22nd March 2020, Honorable Prime Minister said, you close everything. And that day was light has gone forever. But all of a sudden, technology started coming. And within a month, things have transformed. And what we learned, how technology can be a useful tool in dissemination, promotion of education, and also in the functioning of the institutions, judicial institution, executive institution, and others. So it has saved. And best part, that we are finished, we are over with the COVID phase, but we continue to use the technology. And a lot of just I read in the newspaper, Sankhla sir, the issue related mandatory attendance. Why mandatory attendance should continue when students can have all the information? And Honorable Justice Pratibha Singh, and I think she has given a direction to the Ministry of Education to contemplate why education, mandatory attendance is required in the law school and other schools also. But technology has significantly transformed our education system and our and making it more inexpensive. The two important points, inexpensive and accessibility, have increased. A student sitting in far away places in India or abroad also can participate in the Moot Court competition without paying much money. The hassle bustle of preparation, buying ticket, visa. So a Moot Court can be extended beyond territory, and I hope that Sankhla ji will take and in next program make it more, or maybe you can introduce another one which will have an international dimension as well. So that can be done. We should connect with the other universities. We should also interact with them and understand how they addresses a particular legal issue, and that will helpful for our students and also students. Students can also realize where they stand. There are students, they are going and participating in international Moot Court competition, but they can also realize staying in the country, they get best facilities, whether it's education, whether a Moot Court problem. And the team which competes in the Moot Court competition, they are all, as Nivedita mentioned, they're equally brilliant students. And the trend which lordship is important to note, in the Moot Court competition, some way monopoly of the few law colleges have been broken. In one point of time in 20 years back, any Moot Court competition, the final always used to be owned by either Bangalore or also by Hyderabad or maybe one or two other law schools. But we see the trend that now number of new schools, law schools, private as well as the young national law schools, they are giving tough fight to the top law schools in India. And that is some way it has become inclusive, and students also challenge top law school students. We are equally prepared. So that is a very new good trend where we see that it motivates many students to participate. They come forward, and also I have gone through the result. I say today is also an inclusive, where we see that a lot of teams from different private law schools are managed to come or succeeded in the final round, and they are going to receive the award. Just to conclude to all the young students, that you should continue in the participating. If you want to continue in the legal profession after your degree, continue to participate in the Moot Court competition, debate competition, and that will create an environment for you which will help you to succeed in the legal profession. When you speak before honorable judges, honorable lawyers, I'm sure that will remove some of the concern that whether I can speak, whether I can do well, and that will help you to save. So I request all the students to continue and participate in the Moot Court competition. And in the end, I request Sankhla sir to continue this third, fourth, annually, make this is an annual event. I believe it's an annual event. But if I calculate with the years, it looks like 1 or 2 years gap is there. So we can 24, 25, 26, and also the suggestion, if possible, you can consider it making international as well. With this, again, I thank honorable justices for I feel very honored that I'm sharing guys with the honorable justice Jahasarsi, Sahasar, and all of them. Thank you very much.
Thanks, sir.
Thank you so much, Manoj sir, for such a humble and engaging speech. Your active participation and thought-provoking ideas, especially on adding an international touch to the next edition of the competition, has greatly enriched the event and provided us with much to reflect upon. Now it is both an honor and a privilege to introduce our esteemed chief guest for this valedictory ceremony, Justice Subodh Shah. Justice Subodh Shah is a distinguished former judge of the High Court of Gujarat, renowned for his pioneering contributions to the Indian judiciary. A trailblazer in legal technology, Justice Shah was the first advocate in India to embrace computer technology as early as 1985. His visionary work has been instrumental in the computerization of the new Gujarat High Court complex, the Supreme Court of India, the Madras High Court, and all district courts in Gujarat. Furthermore, his leadership in the E-Committee has significantly advanced the computerization of the entire judiciary across India. Justice Shah's innovative spirit is exemplified by his development of the e-court concept, a first of its kind in India. His efforts have transformed how legal proceedings are conducted, making justice more accessible and efficient. His role as a member of the Standing Committee of the Supreme Court of India for monitoring this e-court project underscores his pivotal influence on modernizing our judicial system. Beyond his contributions to legal technology, Justice Shah has a remarkable career as both an advocate and a judge. He has handled an extensive array of cases across civil, revenue, constitutional, and criminal law. As a city, civil, and sessions judge, he resolved 1,388 cases in just 174 days, showcasing his efficiency and dedication. His tenure as a CBI judge saw him tackle complex matters, delivering 88 judgments in 138 days and handling numerous discharge applications and witness examinations. During his time at the Gujarat High Court, Justice Shah delivered approximately 19,832 cases, judgments in 1,260 days, reflecting his profound impact on the legal landscape. His expertise is further highlighted by his engagements with the forensic science community and his participation in the Asia Pacific Conference in Singapore. Justice Shah's extensive experience in the Lok Adalat and mediation cases demonstrates his commitment to the alternative dispute resolution and his comprehensive understanding of the law. Tonight, as we celebrate the achievements of our participants, we are deeply honored to have Justice Subodh Shah with us. His exemplary career and pioneering work serve as an inspiration to us all. Please join me in extending a warm and heartfelt welcome to Justice Shah.
Thank you, Kulu, to say so many things in favor of my personality. Honorable Ravi Shankar, former Chief Justice of Punjab and Haryana High Court, Dr. Manoj Sinha, Kapil Sankhla, Nivedita Chauhan, all other participants, brothers and sisters. I have 2 points to discuss or to vouch about. One is moot court and second is technology, as since it is the requirement of the day. So far as moot court is concerned, as usual, everything has a two side. Every coin has a two side. So this moot court competition or moot court concept has also two sides. See, we learn or we studied law without any such facility of moot court. And you will surprised to note it that during the time when I was student, it was said that many a times a gold medalist law student may not be able to be a successful lawyer. He may be, probably he may be a successful judge or a successful academician, but a last bench student in a law class may be a successful lawyer. Because during those days, moot court like competitions were not there. What it means, actually learning a law is learning any other subject. But practicing a law in a courtroom is altogether a different issue. And that is you are being taught or you are being given a platform to know that how to act, how to conduct a case, how to apply a law to the facts, given facts in a courtroom. Knowledge of law, knowledge of section is one thing, and application of that law, that section to the facts of the case is altogether a different thing. And the best skill is how to represent it before the court. It was never taught to law students before the decades or so, but now we are thankful to institutions and companies like Sankhla and Associates and other universities that they manage such big moot court competitions where they are inviting students from entire nation or even internationally, and they allow you to compete with each other. Just day before yesterday, I was in similar program of valedictory session of National Moot Court competition in Parul University at Vadodara in Gujarat. There, a pair of one college, I don't recollect the name, but of Himachal Pradesh has been the first prize. So now that barrier has been broken as Mr. Sinha has said, that everyone has a chance to show your competition. So you must try your competition, competence, and you must show your competence in such moot court competitions. At the same time, now the other side of the moot court competition, some may like or may not like it, but I tell you, whoever wins this competition or who loses this competition, neither of you have to worry about it. Loser has not to worry, and winner has not to be much of proud, for two reasons. The first reason is, it is a chance that such a case is assigned to you, such fact is assigned to you, that you don't have a chance to argue it in a better way. I'm saying so with a different concept or perception. Please rest assured that after winning such moot court competitions, if your skill to argue is proven to be better, rest assured that in real court, only your skill to argue in a better way would not be enough. There must be better facts, and there must be better application of law to those facts, and then your skill to submit it properly before the court. Whoever is keen to be a judicial officer in future, or whoever wants to do practice except going to corporate job sector, please rest assured, Justice Jahan will pardon me, that in courtroom, your skill will not be, your speaking skill, your representation skill will not be counted as a sole ground to succeed in the case. But facts and law applicable to the case would only prevail, and it will survive. It may be true that some senior, I am saying, pardon all the senior counsels, some senior counsels may be given a so that they are succeeding or they are very good in arguing this and that. But I tell you frankly, ultimately it is fact and law that is winning point or winning concern for you. The senior counsels, because when you win this moot court competition, some of you may be under impression that I am very good in moot court competition, I am very good in presenting case, therefore I would be senior counsel. Please be careful unless you understand facts of your client, as Nivedita has said, without considering the monetary benefit received from the client, and unless you apply the law properly to such fact, and thereafter, unless you place it properly before the court, you may not succeed in a trial, any civil, criminal, or any case. So, no doubt, moot courts are very good for all of you. You must take participation, but rest assured, either you lose or win, it does not make any difference for your career, either as a judicial officer or as an advocate. But at the same time, we must be thankful to such institutions and the companies who are promoting such moot court, because it is very much necessary during this phase. The second point is regarding technology. I would not have spoken or speak anything about technology, but when Nivedita has said that please don't use artificial intelligence too much, I have a second or different thought, and therefore I have to say something to all of you. I have allowed Kundu to say everything about me only because I have to speak something on technology, otherwise I would have stopped her. I am using computer since 85. And my office was computerized in 88. When I say computerized, since 88 as an advocate, I never need a full brief in a courtroom. Only few pages print, because during those days, smartphone, tablet were not available. So I have to take printout from home computer or big computer, install it in the office. And those 2, 5 or 10 pages are sufficient for me to argue entire case before the court without bulky physical files. The other thing is, before SCC and AI are online, legal databases are available in the market. I have my own legal databases. I have engaged 8 data entry operators in 88 and developed my own in-house legal database. Now, why technology is required? Because practically law is an ocean. As Kapilji or somebody has said that even after a couple of years or decades, we are still learning law. So for a young lawyer, knowing everything of every case within given short time, within couple of days or couple of weeks, is very difficult. Because of that concept, I have started to use computers since 88. And so far as artificial intelligence is concerned, even today I am working on it. And just a minute. It is to be understood, or it must be realized, that when we use artificial intelligence, it is not only machine or technology, but again, it is only when some good data is fed in the computer, and then artificial intelligence churn that data and give you some reply. So practically you are getting an output from a wide area. The data or the information which you are unable to access physically or because of time constraint. But it is when it is available in a computer system, cloud system, in artificial intelligence or the search engines are churning entire information and selecting answer for you from all possible data available within it. So using artificial intelligence is not to be ignored, because the other reason is think about warfield. If you are going with a lathi or stick only and the other side has a gun, what will be the position? So now when the entire world is using technology, if we say that as an advocate, we must constrain to physical research only, it would not be possible for us to chase the entire world. So, but what Nivedita has said is to be taken differently. That please do not solely rely upon technology. Have your own reading. Have concepts of law and facts clear. If you are not aware about facts, better facts of your client and the applicable law to those facts, those disputes, then probably your search, either in a normal search engine or in artificial intelligence, may not give you proper result. So ultimately, you have to read the facts and law applicable to your client, and then use technology as a tool only, not as a final supporter. I think I have said so many things. Let us now have a good words from Justice Ravi Shanker. I'm thankful to Sankhla and Associates and Amikus Qriae for arranging and managing such a national moot court competition and inviting us to address all of you. Thank you, all of you. Thank you.
Thank you so much, Justice Shah, for your invaluable presence and inspiring advice, which have greatly enriched our segment. Now it is with immense honor and great pleasure that I introduce to you our distinguished chief guest for this valedictory ceremony, Honorable Mr. Ravi Shankar Jha, who has formerly served as the Chief Justice at the High Court of Punjab and Haryana and currently is a senior advocate at the Supreme Court of India. Born on October.
May I request you to skip over this? All of you know me. I know all of you. Thank you
Yes.
so much. Thank you so much for this wonderful gesture on your part. So I won't let you waste time on these formalities. Let's proceed further. Thank you. Justice Shah, Mr. Sinha, Mr. Sankhla, Ms. Nivedita, all young people who are listening to this. been practically coerced into appearing here by Mr. Rupam, having used all his resources. So, but I'm happy that I'm here. I'm glad that I'm here. I'm grateful to all of you for having invited me. Firstly, I need not, I think, elaborate on the topic of the Moot because it has been done quite beautifully by Mr. Sankhla, Ms. Chauhan. But I extend my congratulations to all the participants, winners, and more so to the losers. I say so because, you see, you win a competition and you actually derive a sense of competence. But if you lose it, and if you have that spirit in you, it's a very big motivation to do better, to examine where you've lacked and improve upon it, to see where the others have excelled and adopt it, to come up with more modifications to do better. And therefore, in fact, in such cases, at times, it's a blessing to lose. So I congratulate all of you who have participated in this event. And like Justice Shah said, the moot courts are like net practice. The more you do net practice, the better you perform in the matches. When the real performance is required from you, you are able to do better. But again, like Justice Shah said, nobody plays on the ground in the match the way he plays on the nets. Playing in the nets is very different from playing in the match. The rules are different, the game is different, perceptions are different, requirements are different. And though all of you are guiding these young students and all those principles and rules are common, that one must work hard, honest. One must be honest, be thorough with the facts, be thorough with all these things are, be up to date. I think these are all things, and I could elaborate on them and sound as hackneyed as possible. But at the same time, what one has to realize is that what you really learn in college and in these moot court competitions should not limit your further progress. And no, it's all right. It's okay. It's okay.
We've all been doing faux pas today, my lords. I'm so sorry.
No,
My
it's
daughter
okay.
kept on calling me. My bad. I'm sorry.
It happens. It happens. No problem. So what you have to understand is that so many more and other varied factors are involved when you are arguing a matter in court that it's practically impossible to conceive them in a moot court. You see, like Justice Shah said, there are no set rules for becoming a good lawyer. What works for one person may not work for another. What works in one court may not work in another court. What you have to learn is, most of the times, what you're not required to say, because everybody will teach you what you're required to say, speak, present before the court. Nobody really teaches you what not to say, what to avoid speaking, the way, the manner of presenting things. You may be very confident. You may be very well read. But you must never reflect that kind of or rather not give that kind of an impression to the judge. So there are so many things that you have to learn, and you learn them with the passage of time. And but that doesn't mean to say that moot courts are not effective or are not a very good tool to develop your skill. They are very important. You get to learn how to do research. You get to learn how to present your matter. You learn to, most importantly, analyze the facts and the law chronologically in your mind. And that kind of a discipline, mental discipline in arranging the law, the facts in your mind is something that will help you always. So that's a very nice thing. Mr. Banerjee Rupam, he said something about the fact that the students would, or the children here participating would be learning something about constitutional morality. That's very nice, because you see, on morality and ethics are those unwritten rules on the basis of which you actually interpret written rules. They are unwritten rules, but you must know them. You must know them thoroughly. Only then you can properly interpret law. The Supreme Court has actually recognized these concepts. Constitutional trust is a concept that was recognized by the Supreme Court in 51 in the Delhi Laws case. Constitutional morality is a concept that was again recognized by the Supreme Court in the case of Manoj Narula in 2014. So you see, these are very good things that one, and I'm sure these children who participated here must have learned a lot about these things. And but there is one thing that I would definitely advise the young children. You see, you must know the history, legal history of your country. Your country, I'm emphasizing this. Today we are all the time talking about globalization, what is happening in this country, what is happening in that country. If you ask new children today what's happening in America about the child law, women law, it's on the tip of their tongue. If you talk about what is the law in Britain, they'll tell you immediately what's going on in Switzerland, Sweden, this, that. But you ask them what's going on in India, and perhaps they won't know anything about it. It's unfortunately, this is the situation since the last 15, 20 years I've been at this. And I've tried to obliterate this impression from the mind of students, children, professors, everybody, that the legal system in India is the birth of the Magna Carta or the Charter of Rights. And these are 12th century things which did actually babies, not even babies, in front of the legal system of India, which is thousands and thousands and thousands of years old. Nobody really talks about them. Nobody studies them. There are 18 available smritis. Gautam, Vashisht, Narad, Manu, this, that, nobody has read them. They are all laws. They are all codified. Dharmashastra. There are so many other. In fact, you'll be surprised that the way of drafting a plaint, the manner of drafting a written statement, the manner of adducing evidence, the quality of a judge, the manner of writing judgments, all these things were codified, known to us thousands and thousands of years ago. And fortunately, we have written proof of all that before us. I had the opportunity, by the blessing of God, of being the Chancellor of 3 NLUs. And also had the good fortune of actually establishing DNLU from scratch. Like Mr. Sinha said, from the building to the present site, the new site, the staffing pattern, the budgets, everything was designed. In the motto, the logo is written Vice Chancellor DSNLU. It's not DSNL because Dharmashastra is one word. There was a lot of debate on the word, this name also. Because you see, you won't find this kind of a name anywhere in the country. It's either in the name of some great luminary or it's some juristic European name. So I had great difficulty in actually giving this name to this university, Dharmashastra. Nobody actually understood what is the meaning of Dharmashastra. Everybody thought Dharmashastra means it's totally Indianized, this thing. What does Dharmashastra mean? Nobody knows. In fact, I had to give a lecture on this. What is Dharmashastra? So you see, Dharmashastra, and in this, what I was trying to tell you is that it was my effort to see that the book which is approved by the Bar Council of India, Legal and Constitutional History of India, written by Chief Justice Rama Joyce, is a wonderful book that must be seen and must be read by all students, professors, teachers. Part of it was included in the curriculum. I don't know what's the situation today, how things have changed, because faculties are not well versed with these things. They've not read these things. I was presented a book by Professor Ranveer Singh, written by his professor, Professor S.D. Sharma, is the Administration of Justice in Ancient India. The preface of the book was written by Justice Sikri. And he says that it's so unfortunate that there's such a big divide, gap, a lacuna between the present constitutional system that we have adopted and the ancient one that is actually prevailing in India. Because you see, one must understand the practical reality that you make a law sitting in an air-conditioned room in Delhi and you implement it in Abu Juman, in Jharkhand, on the Bhils, on the Begas, who are still living as per the old social traditional systems. So it is my request to all students, it is my request to all of you to read these things. There's a wonderful commemorative volume released in the honor of Mr. Parasanan, senior advocate. Law and Dharma, a wonderful book again written there. So you must read all these things. It's necessary and important because it will give you a very, very deep, a very, very special insight to the very object and purpose of the laws. Your thinking will change. Your manner of interpreting the laws will change. See, today in this Moot, you are talking about rights. Right of A, right of B. Today, it is very unfortunate that whereas the system in other places is shifting from individual rights to duties, we are still stuck up in these issues. In fact, the lawmakers understood this problem, and that is why I introduced the chapter of fundamental duties in the Constitution. Today, nobody is talking about them. All moots are on constitutional issues. These young people, when they enter the profession and they encounter their litigants, clients, Mr. Sankhla is there, Chauhan is there. Today, the latest is alternative dispute arbitrations, mediations, this and that. And the law involved in that is what? Contract Act, Transfer of Property Act, Specific Relief Act, Evidence Act. I don't find anybody talking about these things. I don't find any moots being held on issues relating to these laws. They are all on abstract constitutional issues taken up from some foreign country of some form, is relating to LGBTQ+, it's relating to women, it's related to human rights, it's relating to individual fundamental rights. But what about these legal issues which these students actually will be studying, implementing when they enter the profession? So there's a need for a little bit of shift. This is my opinion. I am maybe outdated. I may be wrong. But I feel that these are the issues that you really need to take up and educate the students on. It's you see, when you go in for research, I think I need to clarify a little about this thing, what Ms. Chauhan was saying about AI and what Justice Shah said. What Justice Shah said was absolutely right. AI as a tool in aid is very good. But what probably Ms. Chauhan was referring to was this new generation, I don't know what is called regenerative AI or whatever, where even the drafting is done by the computer, the arguments are prepared by the computer, this thing. And in fact, there was a conference amongst lawyers where they said that we have to stop this, otherwise we are going to be out of the profession altogether. Because the client will simply feed all these things into a software and come up with his plain, he'll come up with his arguments, he'll present it, and you're out. So you see, to that extent, you shouldn't go. But definitely to the extent when Justice Shah said that you need to use it as an aid, but don't use it to the extent where it replaces you and your existence ceases to have any meaning. So these are the things. As young lawyers, they have to, like I said, work hard, be honest, this, that, but there are a few things that they must know and they must keep in mind always. And because everybody is talking about success. Here, all these moots, all these students who are taking up law, unlike my time, when we took up law either by default, because we were not getting admission in any other course, or we took it up because of compulsion from the family or somebody or something, someplace. Now, law is taken up as a profession. And the kind of children who are joining it, they're very, very concerned about the future career in the field, monetary success, fame, name, all these things, which are actually those things which we were taught never to think about in this profession. Today, those who are successful are only those. You see, there was Ms. Chauhan took up an issue. I'll tell you, I've because I had the misfortune or the fortune of doing some research on this. Coming from a legal background, therefore you're successful. The biggest myth, if you ever analyze what is the status of those who are coming from legal background in the legal profession, you will find only 5 to 10% of them succeed. And they are also those ones who have actually worked hard, who have actually done some work, and who are delivering the goods. You see, this is a profession. Nobody comes to you just because you are somebody's so-and-so's son or so-and-so's brother or so-and-so's husband or wife. They come to you because, you see, if you are ill and you have cancer, you have prostate cancer, you will first find out who's the best doctor in that field, in that particular branch, and go to him. You won't just go to another doctor who's the son of a doctor who was a cancer expert. You won't. This is a profession. There's a difference between profession and service. You must know this. This myth should go away from your mind. So hard work, honesty, these are the things that you... Now in today's time, the change perspective, which I feel, and which will be the future of the judiciary, we need people who are duty-oriented, service-oriented, people who are nationalists. It is absolutely important. You are talking about individual rights. I am talking about national rights, where you see what is in national interest is much more important than what is in individual interest. The progress of the nation is much more important than the progress of your financial progress or the progress in the professions. See, there is a slok, and I've quoted it on the cover of the book, the judicial history of the courts of Madhya Pradesh. It says that dharma or law is that which results in the society becoming more close-knit and stronger, and its upliftment. Dharma is certainly that which benefits everybody. It does not talk about benefit to an individual. You see, the laws are made to have some kind of a regulated system in society. It is not made to benefit an individual. One has to have this concept in mind. You see, as a judge, you may come up with an individual case where you feel that though the person has committed a crime, you should deal with him leniently. And in that particular case, you do it. Now imagine what is the impact of this judgment. The impact on the society is that you can get away by committing a crime if the judge is kind, if the judge is lenient. This is doing violence with law. You have to see that whatever you do, sends a very correct, right message to the nation, to the country, to the people of the country. So these are the things where you have to now change a little bit of your thinking. Don't always talk about individual rights and this thing. Be a little bit of a nationalist. Young students should always remember two formulas of success. They are always in front of us. They are imprinted in our mind, but we ignore them. The first is the motto of the nation. Satyameva Jayate. Truth alone triumphs. Truth alone succeeds. The second is the motto of the Supreme Court. Yato dharmas tato jaya. The righteous only win. It is only righteousness that succeeds, nothing else. In our greed, in our hurry to become successful, in our passion to become rich, famous, we indulge in so many things which are not in accordance with either Satya or Dharma. Remember, you will always fail. But if you are patient, if you are walking the sacred path of Satya and Dharma, this is the guarantee given by all these 20, 30 years of experience by these great learned scholars that you will succeed. You will succeed. The question is, what are the things that these students, these children, my young friends should practice in the court as lawyers? Like I said, there is no answer with me. There is no single answer with anybody. Like I said, something may succeed with somebody, something may not succeed. With the same thing may not succeed with another person. One thing may be very useful and helpful in front of a particular judge. It may not be very helpful or successful with another judge. So what should be done? So you see, the people in ancient times also asked the gurus, what should be the path that we should follow? And there's a wonderful answer to this in the one parv of the Mahabharata. They say, Tarko apritishta shastro vibhinna neko rishi yast mata pramanam dharmasya tattvam netam guhayam mahajano yena gatasya pantha. It means that on every issue you will find hundreds of arguments. You will also find hundreds of opinions. You will also find that on a particular issue, there is no one common opinion of all the learned people. The opinions will all be different. So what to do? And the real truth is so difficult to ascertain that it takes a lifetime to understand it. So what should a person do? Mahajano yena gatasya pantha. What does that mean? Whatever the learned, great people who have achieved success in that field, just follow them. So my request to all these young friends of mine is that whichever field you go, join a senior. Don't become a senior from day one. Join a senior. You may feel that he doesn't know anything or you know more than him. You may feel at times that he is making a mistake, whereas you could have done much better. But still stick to him. Stick to him. Give him time. Give him 3, 4 years, 5 years, 6 years. Follow him. If you want to know how things are argued, one of the best arguments between, there are so many texts. The argument of Ram and Bali. The argument of Hanuman before Ravan. The Gita is an argument of Krishna before Arjun, compelling him, forcing him, making him understand why he should do his duty. In today's time, you have Bhola Bhai Desai, you have Nani Palkiwala, you have Mr. Parasaran, you have so many learned people to follow, plus your senior. Mahajano yena gatasya pantha. Just follow. They will teach you how to practice, how to be successful, how to put things before the judge in a manner in which you may know more. You see, at times I have seen cases myself, where a judge was with a lawyer from the first moment he stood up. But because the lawyer argued too much, he lost the case. You see, you have to know when to stop. You see that the judge is with you, you have to stop there. But in your anxiety to show the judge that you knew so much, or you know much more than the judge, you lost the case. When I joined the profession, you see, at that time, this constitutional practice, especially in states like Madhya Pradesh, was not very developed. And when I came up, I said, I'm a master of fundamental rights. 14, 19, 21, that's my Bible. And in the first cases I argued, I took so many citations and books, and they were thoroughly prepared with facts, argued before the judge. The judge heard me patiently, smiled, and then dismissed the case. And I came out and I said, oh, the judge doesn't know anything, and this and that. And I said all those things. And this happened to me in the first year of my practice. After 6-7 years of practice, I got a similar case. And then I remembered that incident and I was laughing on myself. Because after 6 years, 7 years, I realized that what the judge had done was right and what I was saying was wrong. So you see, what you learn in college, the academics that you practice, Justice Shah rightly put it, there's a whale of a difference between academics and actual practice of law. So you feel that there is something in it, but there are so many. See, 226, Article 226 is considered to be so wide. Everybody, any person, authority, this, that, writ can be issued. Anything. Once you study Article 14, become thorough in it, you realize that there's a very narrow passage only in this 226 through which you can go. Otherwise, there is so much of law. So you see, what I'm trying to tell you is that you need seniors for this. You need that guidance for this. So be hardworking, be honest, be a nationalist, join a senior, learn from him. Mahajano yena gatasya pantha. Turn out to be a lawyer of metal. Take examples of Bholabhai Desai and Palkiwala who had the guts to throw away the attorney generalship just because on principles he did not agree with the government. At a time when the government was so powerful that it could do anything to you. So please learn these things. Remember these things. Time is short, and I think I've taken up more time than was given to me. So once again, I'll thank all of you for having invited me to this Moot Court program. I'm grateful for the opportunity given to me. I congratulate all of you, and I think, Mr. Banerjee, I have one more task, very important one to perform. Declare the result, maybe, or right now, or when, Mr. Banerjee?
Yes, sir. Disclose now.
Have I to do it right now or later?
Just you will be doing it at the end. So please continue.
Okay.
Right
so
now.
then I rest my case. Thank you.
Yes.
Thank you for having given me this opportunity and this chance to may say a few words to all of you. I samasta loka sukhino bhavantu. I bless all of you with success and happiness.
Thank you, madam.
Thank you, man.
Thank you. Thank you.
Thank you, Justice Shah. Now coming to the most awaited moment of the ceremony, we'd like to commence the announcement of the competition results. I'd like to request Dr. Manoj Kumar Sinha to announce the best researcher. Sir, you're unmuted.
Best Researcher Award goes to Harsi Agarwal, Bharati Vidyapit Institute of Management and Research.
Let's have a round of applause for the best researcher. Now, I'd like to request Mr. Kapil Sankhla to announce the best speaker.
With absolute pleasure, the best speaker for this year is Miss Ananya Gupta of Delhi Metropolitan Education, GGSIPU. Heartiest congratulations to you, Ananya.
Let's have a round of applause for Miss Ananya. Now I'd like to request Justice Shah to announce the winner for the best memorial.
The best memorial team today is team number 356 of Army Institute of Law, comprising of Samsun Nahar Khan, Sakshi Tanwar, and Anchal Sharma. Congratulations to all of them.
Let's have a round of applause for the best memorial. Now I'd like to request Justice Shah to announce the second runner-up of the competition.
The second runner-up of the competition is team number 345, again from MIT Law School, MIT University, Noida, comprising of Farisha Chaudhary, Suvista Jain, and Anupriya Pali.
Congratulations to the second runner-ups. Now I'd like to request Justice Jha to announce the runner-up of the competition.
Runner-up, winner.
Winner.
Runner-up, huh?
Runner-up, Justice Jha.
Runner-up is team number 343, St. Xavier's University, Calcutta. Joshua Atik, Antika Das, and another Antika Das. Congratulations to all of you.
Congratulations to the winners. Now I'd like to request Justice Jha to announce the winner of the third edition of the Sankhla and Associates National Moot Competition 2024.
Oh, the pleasure. Well, I was Chancellor of this university also. Rajiv Gandhi National University of Law, Patiala.
Oh.
Tanvi Gupta, Adit Seth, Mahreen Sihak. Congratulations, young lawyers. Congratulations to all of you.
I've had the pleasure of teaching there as well, Manoj. It's a wonderful university.
Oh, yes.
Congratulations to all the winners.
Congratulations.
Now I'd like to call upon Mr. Rupam Banerjee, founder of the Amikus Qriae, to extend a vote of thanks.
Thank you, Somali. I hope I'm audible.
Yes, absolutely.
Thank you. So, ladies and gentlemen, as we draw this remarkable valedictory ceremony to a close, it's my distinct honor to express our heartfelt gratitude to everyone who has contributed to the success of the third edition of our flagship event, that is Sankhla and Associate National Virtual Moot Court Competition 2024. First and foremost, a profound thank you for our esteemed Chief Guest, Honorable Justice Ravi Shankar Jha, sir, former Chief Justice of Punjab and Haryana High Court, for your insightful presence and for the event. We are deeply grateful for your time, for sharing your wisdom with us. We also extend our sincere appreciation to the Chief Guest, Honorable Justice Subodh, sir, former Judge of Gujarat High Court. Your participation and encouragement have been invaluable, and I'm honored to have you as today, sir. My heartfelt thanks to go to our distinguished guest of honor, Professor Dr. Manoj Kumar Sir, Vice Chancellor, DNLU, Jabalpur, and Ms. Nivedita Chauhan, ma'am, co-founder as Chambers of Abhinav, Mishra, sir, for their support and presence. Have greatly enriched the ceremony, and we're truly grateful for your contribution. Thank you, ma'am. Thank you, sir. Special recognition is due to Mr. Kapil Sankhla, sir, our Patron-in-Chief, Managing Partner of Sankhla and Associates, our joint organizers, and our forever support system. Your unwavering support and dedication have been pivotal in bringing this event to fruition. We're grateful to our sponsors, Sankhla and Associate and Chambers of Abhinav Mishra. Without support, this competition has not been possible. A big thank you to Mr. Kuldeep Baira, sir, and his team for crafting the moot proposition with such thoughtfulness and precision. Your work has provided a challenging and stimulating performance for the participants. Our deepest appreciation goes to the organizing team of the Amikus Qriae for their exceptional work, effort, and dedication. Your hard work behind the scenes have been instrumental in success of the event. We also want to acknowledge our media and support partners for their vital role. I especially want to thank our conveners, Aditya, Soumya, co-conveners, Atri, Shufia, Manshi, Sakshi, and Anushka, even Nikita, if I forget any names. Thank you really so much for doing all these things. Finally, congratulations to all the winners and participants. Your hard work have been creative. Commitment have been truly inspiring. Each one of you has been contributed to the success of this competition, and we are truly incredibly proud of your achievements. Thank you once again for making the competition a memorable and successful one. Have a wonderful evening and looking forward for the further edition. Thank you so much, sir. Thank you so much. Yeah.
Thank you, Lordship. Thank you.
Thank you all of you. Thank you all of you. Thank you, Jessica.
Thank you very much. Thank you, everyone.
Thank you.
Thank you.